High Court motto is the Satyamev Jayate. And your Lordship submission is the Yato Dharmastato Jaya, because Dharma is above the Satya. So I have dealt, my lord, in third part. As far as the, my lord, Article 25 and 26 is concerned, my lord.
We come to third part, that's better. No? That's a new point you are raising.
No, I will also, my lord, say, just see the constitutional oath of your Lordships and constitutional oath of the ministers, union ministers, and the constitutional oath of the ministers. So Lordships oath.
Whatever you want, you have asked for 10 minutes, we have granted you 5.
My lord, this is totally new, my lord. Totally new.
For 10 minutes you have asked.
Yes, my lord, definitely.
Please confine that.
So Lordship's oath is to uphold the constitution. Just see the Schedule 7. Oath of the legislature and executive is act according to the constitution. Upholding the constitution has higher value than acting according to the constitution. Third, my lord, Bharat have been divided in last 2000 years in 25 pieces. That was not due to religious conflict between individuals. Bharat divided in 25 pieces in last 2000 years due to denomination conflicts. And in last 200 years, Bharat divided in 7 countries. Third, my lord, I have also considered that every action has a reaction. Similarly, every judgment has a ramification. Being an engineer, my lord, earlier I was an engineer. So I did the 5W analysis, the Wi-Fi analysis. What will happen if the Lordships will accept my senior's argument? What will happen if not accept argument? What will the ramification? Whether in the next 25 years, we will become a united, integrated, scientifically developed country like China, Singapore, Japan, or in next 25 years, we will become countries like Pakistan, Afghanistan, and Bangladesh. So I have all the reasons, my lord. Let me see the Article 25 and 26. Article 25 and 26 is the most restricted provision. None of the fundamental rights so restricted, my lord. Right to propagate religion has not been given in those 10 countries. From we adopted some parts. The 10 countries we have taken something from the South Africa, from Germany, etc. my lord. Even those countries have not given right to propagate not only the denomination, even to the individuals, even till date. So Article 25, subject to public order, health and morality, subject to 27, subject to 28, expressly subject to other parts of the provision. Article 26, subject to public order, health and morality, impliedly subject to other provisions, and expressly subject to 27 and 21. My submission is, my lord, 26 is the SPC, 25 is the genus. SPC cannot have the wider area than it's a genus. So, my lord, just see the brief. The 9 judges bench of this honorable court will not only decide the 7 questions of law, but also decide the future of the country for next 7 decades. The interpretation of Article 25-26 will decide whether we would achieve the golden goals of the Constitution and become a united, integrated, and scientifically developed nation by 2047, or a radicalized country full of superstition, black magic, delusion, and dogmas. The sui generis case of Sabrimala is not being assailed here. Is it a long-standing custom which is in consonance with public order, health and morality, and other provisions of Part 3? I have dealt in para 22, para 32, 30.
Straight come to the point, Mr.
Yes. Then, madam, main argument. Just see the middle, main argument. Just I request, madam.
That's right, but we don't have
yes.
time.
Then summarize your
We have to grant time to the others also.
The main argument, individual possess the right to propagate religion, while the denominations do not possess such right. The Constitution framers put the express restriction of the being subject to Part 3 in Article 25, while not doing so deliberately on Article 26, as Article 25 granted the right to propagate religion on individuals, while Article 26 did not grant any such right to any denomination or sections thereof. Even the anti-conversion laws enacted in the different states are based on the premise that only an individual can propagate, convert lawfully or unlawfully. The intent of the premise was also, as the root cause of the 1947 partition was denomination versus denomination conflict, not the individual versus individual conflict. Had persons propagated their religion peacefully, such a conflict would not have arisen. Notably, the 10 constitutions from which we adopted various parts of the constitution, neither back then nor even today have the conferred right to propagate religion on their citizens. Only after much deliberation was this right included in the constitution with an express subjection to the other fundamental rights, keeping in mind its a dangerous nature. All the other articles are already impliedly subject to the other fundamental rights. Well, there is some argument. It was tried to connect Article 2930 with the Article 2627. My submission is this. Though Article 2930 have been tried to argued in this case, but they are not relevant in this case. Minorities were given certain protection in regard to their culture and education. Therefore, Article 2930 covered under cultural and education right. Had they been intended to confer religious right upon minorities, the framers would have not been made their heading to so exhaustive. Thus, Article 2930 are not to be dealt with in regard to right to freedom of religion and should be seen as completely distinct from them. The observation in few cases that Article 30 is an extension of Article 26 is therefore per incurium. My lord, petition is pending and before the refer to the 7-judge bench. Next, my lord, I have considered, my lord, few points. Number one, the dreams of the freedom fighters, the dreams of the constitution makers, the language restriction